All right, good afternoon, everyone. It's a pleasure to have you all here. Welcome during your noon hour to join us for part of our Distinguished Visitors Lecture Series. With us today is a really fantastic scholar who's joining us to talk a bit about defamation law in the internet age. Her name is Dr. Hilary Young. Dr. Young is currently an associate professor at the University of New Brunswick's Faculty of Law. She comes to us with a PhD in linguistics from Rice University. She did her LLB at the University of Ottawa, where she won the gold medal. So we have a real brainy one here, my dad. She did her LLM at Harvard Law. She also clerked at the Supreme Court of Canada with Justice Louis Labelle. And if that wasn't outrageous enough and impressive altogether, she also litigated after at a firm in Halifax, So she's going to be joining us today, and her specialty areas include defamation law, but also health law with respect to informed consent. So we're in for a real treat today, and look forward to hearing what you have to say and the questions that come after. So please join me in welcoming Dr. Young.
Thank you so much, Omar, for that very kind introduction. Is the mic working? Can you hear me all right? Okay. So today I'm going to be talking about Canadian defamation law in the internet age. So we're going to cover everything and solve all the problems. Shouldn't be difficult. No, I mean, in a nutshell, defamation's an old tort. We've got new technology. What problems does this create, and what might be some of the solutions? Obviously, we're just going to be talking at a fairly high level, but I am going to get down into two particular examples. So I want to start with a quote. "One would be forgiven for wondering whether defamation, which once served the decidedly medieval purpose of averting blood duels among easily inflamed British noblemen, might be on a collision course with the emerging communications technologies of the digital age." I really like this quote. It's from Robert Denay, who is now a lawyer at the Office of the Attorney General in British Columbia. You can tell he's got a bit of a sense of humor. It's a really great paper if you're interested in this sort of thing. But he sets out nicely this, the issue, right? You have this ancient tort, 17th century, and some new technology. And as you likely know, defamation law is fundamentally about reputation, but it's also about speech that harms reputation, which means that free speech issues are always going to arise. And this is the really difficult balancing act that defamation law tries to grapple with constantly. And as our society changes, the way in which we do that balancing changes as well. The next quote is also, the next slide rather, is also a quote from Lord Bingham, who formerly of the UK Supreme Court, I think former Chief Justice of the UK Supreme Court. And he wrote an introduction for a book called The Law of Defamation in the Internet, in which he said, almost every concept and rule in the field of defamation law has to be reconsidered in light of the internet. This is a judge, this is someone used to common law reasoning. The law always has to evolve with society, but there's a sense in which there's something particular about societal changes, particularly changes in communications technology and the law of defamation, that might call for more than the usual common law incremental changes. And so Australia has had statutory reform. The UK has had statutory reform. Ireland has had statutory reform. The Law Commission of Ontario is presently undertaking this huge project on reforming the law of defamation, and its explicit focus is on technology and the changes that requires. Okay, so just a quick outline of what I'm going to talk about today. I'm going to give you all a quick and dirty introduction to the law of defamation so that we know what we're talking about. I'll provide a little bit more of the historical context to show why the present context is relevantly different. And then I'll focus on two particular issues. One, that of internet intermediary liability. That's a mouthful, and I'll explain that when we get there. And one of what I've called here an effective remedy, sort of the takedowns issue. So as I've said, defamation's about protecting reputation while not unduly burdening speech. So let's look at what that actually amounts to in terms of a tort. Elements. Okay. I set them out nice and clearly on the slides for you. Defamatory meaning. This essentially means it's an objective test. Would an ordinary person think less of the plaintiff? So note, that's not a test of reputational harm exactly. Those things should be related, but it's an objective test. Would an ordinary person, hearing what you said, reading what you wrote, think less of the plaintiff? Note also that there's nothing in there about it being true or wrongful or anything else. It's just, would they think less of you because of it? Identification. Was the plaintiff identified? Is this speech about the plaintiff? You don't have to name them. It can be implicit. If I say the Prime Minister, you know I mean Justin Trudeau. If I point at someone, you know who I mean, right? This is rarely an issue, right? This is not a big deal. It's often conceded. Anytime you use someone's name, picture, this is not where a lot of defamation litigation happens. But it makes sense that you require it, right? Because defamation is about harm to reputation. And if you don't identify the plaintiff in conjunction with this defamatory statement, then you haven't hurt their reputation. Publication. Okay. This is the one that I've spent a lot of time thinking about over the last few years. Was the statement communicated to at least one person other than the plaintiff? And again, this makes sense if defamation's about reputation, right? Because it's not about offense, it's not about being angry, not liking what you said, it's about making other people think less of you. So you have to communicate beyond the plaintiff. Again, this is often not a difficult element to satisfy. Anything you publish online, anything you publish in a newspaper, anything you say in a crowded room where people can hear you and speak the language is published. And that's it. That's all the plaintiff has to prove. It's not very much if you think about it, right? There's nothing in there about the statement being wrongful in any way. There's nothing in there about harm. There's nothing in there about fault. Most of that stuff, to the extent defamation cares about it at all, happens in the defenses. So let's look at the defenses. And I'll go through these probably more quickly than they deserve, just because otherwise we'll be here for a long time. But truth, obviously, justification. Defense of truth or justification. If what you say is true, that is a complete defense, full stop. And it doesn't matter if your motives were, improper. That's incidentally not true in civilian systems where your motives it is possible, although nevertheless unusual, for something to be defamatory and true. In common law, it's not. If it's true, you have a complete defense. Okay. Which, good, fair enough, but think about how hard it might sometimes be to prove that something's true. Particularly if you're a journalist and you're relying on sources and it was 6 years ago. And so it's obviously important that true things be protected, but think about what it means that the defendant has to prove it as opposed to the plaintiff and how that might be difficult sometimes. Fair comment. This is a defense for commentary on matters of public interest that were spoken without malice. Won't say anything more about that. Qualified and absolute privilege. Qualified privilege in particular, a very important defense in defamation law. These are not defenses that are unique to defamation law, and they protect occasions of communication, right? So it's thought that in some circumstances it's so important that people be able to speak freely that we're going to give them a defense. So if you defame someone in Parliament, absolute privilege, you can't be sued. Well, you can be sued, but you can't win, right? Your torts profs tell you that. Your profs tell you that, right? Anyone can sue you. Qualified privilege is, the difference is that for qualified privilege, if your motives are improper, you lose your defense. So typical examples would be things like job references or reports to the police, right? If you have an honest belief that your neighbor is assaulting someone and you call the police and it turns out you're wrong, you have a defense of qualified privilege. Responsible communication. Okay, this is one where I have to work really hard not to spend 20 minutes talking about it because I find this one incredibly interesting. It's new. It's from 2009, and it's essentially a defense of non-negligence, right? It's a defense of having taken reasonable steps or having acted responsibly in fact-checking, right? So the idea was that this would be primarily for journalists, although I wrote a paper saying that it's not just for journalists, but let's set that issue aside for the moment. But the idea is you did your fact-checking, right? You tried, you asked the right questions, you did your research, and you got it wrong. Or maybe you got it right, but you can't prove that you got it right? You now have a responsible communication defense. I acted responsibly, and that grants me a defense. A little wordplay I did there. I didn't do that on purpose. Grants me defense. Grant versus Torstar is the case which established responsible communication. Okay, so a fault-based defense, which is brand new, right? That's still the first reference to any sort of fault we've seen anywhere in these slides. I always do this. I print the slides and then I stop paying attention to them, to where I am. Okay. Anti-slap, not a defense. That's why I've got both the space and the brackets. But it's a mechanism for helping to protect the sort of speech side of this equation. A slap, a strategic litigation or lawsuit against public participation. You've probably heard of these, even if not under the term slap. This is the idea that a powerful person or corporation doesn't like what you're saying, and so sues you to get you to shut up or to punish you for your speech, right? Because anyone can sue anyone, right? And that obviously can be very onerous on defendants who then have to, go through one of these defenses and go through a trial process, hire a lawyer. You can very easily be in the high 5 figures and 6 figures just trying to defend yourself. So some jurisdictions, most notably Ontario, have created anti-slap laws. British Columbia has introduced a bill that I think is exactly the same as the Ontario one. The idea is to have a quick and dirty early process proceeding early on to get these cases dismissed. But it's tricky, right? Because obviously slap suits are a bad thing, but how do we know when you've got one without a trial? Right? So that's always the difficulty. You can't deny people their right to a day in court without good reason. And without a trial, it's hard to know. So slap suits are interesting as well, but also not the topic of my talk today. So that's the law of defamation in a nutshell, right? The elements and the defenses. You may have noticed this is a plaintiff-friendly tort. Increasingly less so, but still a fairly plaintiff-friendly tort. It's strict liability, right? Other than that non-negligence defense of responsible communication, I mean, there's no fault. You don't have to intend to defame someone, and not having intended to defame someone is not a defense. It's a little more complicated than that. Their fault does come in relation to publication, but essentially it's strict liability. Presumption of damages. I find this really interesting as well. In most torts, well, I think all other torts, you either prove an injury or you don't. And in some cases, it's fatal if you don't. In negligence, if you don't prove an injury, then you can't prove liability, right? But there are other torts that are actionable per se, where you don't have to prove an injury. But in any event, you're limited to the injury that you prove. You're limited to damages in respect of the injury that you prove resulted from this wrong. That's not the case in defamation. You don't actually have to prove any actual harm to reputation, and greater than nominal damages are presumed as a result. I did a fun, although also kind of aggravating, study of all Canadian defamation law actions over 2 10-year periods. And I've got the source for that at the end. I've got a slide at the end that has the sources for all these things and my contact information. And I'm quite happy for those to be made available to anyone who wants them. So in my study, I found that the average defamation award between 2003 and 2013 was $60,000 in 2013 dollars. Now, it's a bit misleading. The median was about half that. But point being, you're getting damages well in excess of what you would think of as nominal. And also, if you're interested in privacy at all, you may have noted that those numbers are quite a bit in excess of what you normally see for invasion of privacy, which is also often considered kind of similar to defamation. But the damages amounts are radically different. Okay. So presumption of damages, you don't need to prove any reputational harm. You're still entitled to more than nominal damages. No cap. So you probably know there's a cap on non-economic damages and personal injury, right? The Andrews Trilogy. No such cap in defamation, so that sometimes you actually do get non-economic damages that are more than the Andrews cap for a libel. Australia and the UK do have non-economic damages caps. So point being, potentially very high damages. And I'll just note how unusual these things are for tort, right? Tort doesn't like strict liability. Tort virtually never presumes injury. I can't think of any other examples where tort presumes an injury, right? So this is kind of a weird tort, defamation. And I think to understand this, it may be helpful to understand the historical context. So now we'll move on a bit to the historical context. I started out with a slide talking about defamation being about preventing people from killing themselves over their honor. So it goes way back. It goes back to the 17th century. And at that time, obviously only a certain class of people availed themselves of this action. Most people in the 17th century had much better things to worry about than what other people said about them, let alone wrote. Right? So it was a certain class of plaintiff, and that remained true well into the Victorian age and up until relatively recently. So I'm going to speak in generalizations here, but your typical defamation action, again until relatively recently, involved a certain kind of plaintiff, right? Someone with money, often a public figure, someone who had the resources to litigate and cared enough about their public reputation to sue. Definitely a generalization. It's not the case that all actions were brought by politicians and other public figures, but that's sort of the typical case. The defendants also tended to be members of a group or a class, namely those who professionally wrote and published. Newspaper publishers, journalists, authors, right? Defamation is not limited to the written word, and there were slanders, and there were lots of counterexamples to what I'm saying. But your typical action was a public figure suing a professional publisher. And that's important because professional publishers have codes of conduct. They have methodologies. They have professional responsibilities, right? Which is not to say that they never get it wrong and that they never defame people, but at least the law evolved in a world in which that was the context. Another important thing to note about the historical context is that whether libel was written or spoken, its shelf life tended to be relatively short. You write something in a newspaper and it's there, it's printed, the paper could persist a very long time, but realistically, 1-2 days later, it disappears, and it's not to say that people won't remember what was in it if it was sufficiently exciting or controversial, but for the most part, that just kind of disappeared into the ether. And I think the law of defamation really reflects that understanding of the world. Public figure plaintiffs, professional publisher defendants, and speech that didn't necessarily persist for a long time, which is not to say that the reputational harm isn't serious and didn't persist, but you'll see where I'm going with this in a second. So what's changed? Well, a number of things obviously have changed. I think one of the things that's changed is the way we think about speech and the importance of free speech. Obviously, free speech has been important for a very long time, but in the 20th and 21st centuries, I think it's taken on increased importance in liberal democracies, the importance of free speech. Reputation remains very important, but I think the relative importance has perhaps shifted somewhat. It's no longer the case that those defamed, the plaintiffs, and those who want to seek action in relation to a libel is just the written defamation, and slander's oral defamation, sort of. That those who want to sue are necessarily public figures, right? Because it relates to the next point, which is that the defamers are certainly not part of a publishing class anymore. We can all publish to the world at large now anytime we like, right? With potentially very grave consequences. The flip side of that being that the people we defame could be anyone as well and may want to sue us. So you've got those assumptions about the kinds of plaintiffs and the kinds of defendants has disappeared. The persistence issue has changed as well. So I said a moment ago that, even written libels tended to kind of disappear. Clearly with the internet, and in particular search engines, right? It's search engines that make this especially difficult, right? Because anything that's out there about you not only persists, I think it persists on the internet in the way that a printed newspaper persists in the world. But search engines mean that every time you type my name into a search engine, that thing can be attached back to me in ways that weren't possible with a printed newspaper, right? That makes, I think, the world a very different place in the defamation context. So, what does this mean in terms of the law? Well, there's some issues. And as I said at the outset, I'm not going to talk about them all, but just to give you a sense about the kinds of things that arise. Multiple publication rule and limitations. In a nutshell, every time someone reads something, it's a new publication for defamation purposes. Does that mean that there are effectively no limitations periods anymore? Some jurisdictions have tried to deal with this by changing the rule, saying the first time you publish it, that's when the clock starts running. Problem with that being, the first time may not be the one that really harms your reputation, right? So it's tricky nut to crack. Jurisdiction and choice of law, right? I'm about to give an example in a few minutes where Amar defames me. Okay, so I'm a resident of New Brunswick. I'm in Winnipeg. The server on which you defame me, who knows where it is, and the corporate, so it's going to involve Facebook, so they're registered in whatever jurisdiction. The post is read by my brother in Australia. Which law governs and which courts can assert jurisdiction? Well, read Goldhar and Hartz. It doesn't, you know, it's not the final word in all of this, but the Supreme Court dealt with these questions last year in a case called Goldhar and Hartz. That was an Israeli newspaper publishing in Israel, but also online, so everywhere. And the plaintiff was an Ontario resident, and they said he could proceed. Responsibility for republishing. You can imagine you've probably turned your mind to this before, right? If I like something, if I retweet something, if I share it, if I forward it, am I responsible as a publisher? Short answer, very possibly. Because publishing, remember that third element, it's just about communicating, right? Just about making available. I think here the issue is not so much the answer to the question, it's whether we want that to be the answer to the question. Right? Do we want liability to attach to such an action? Okay, I'm going to talk about intermediary liability, and I'm going to talk about the effective remedy issue. Internet intermediary liability. So I think it's easier to attach this to an example. So imagine that I leave here today and Amar posts on his Facebook page that I plagiarized my talk today. Okay. Not true, which is why it's defamatory. Okay, so, but Amar's defamed me, right? Accusing an academic of having plagiarized her work clearly would make someone think less of me. It identifies me. You'll say Professor Young, when she was here, plagiarized her talk. And you put it on the internet, I promise you that's publication. Okay. So, he's defamed me. Has Facebook? That's the question. So internet intermediaries, internet service providers, search engines, content hosts. And I'm just going to use the example of Facebook, although you can imagine the issues are slightly different depending on the kind of intermediary. I'm just going to use Facebook. Okay. Has Facebook defamed me? Well, it's still just as defamatory. I'm still just as identified. The issue really comes down to publication. Has Facebook published? And on the one hand, you might say, well, no, they didn't know anything about it. They had no control over this. They didn't know what was going on. They didn't endorse this. They have no idea, right? But look at what the element actually says, right? It says, doesn't say intended to. It doesn't say, you know, it just says, did it communicate? And in fact, that tends to be understood incredibly broadly in ways that would normally be dealt with concepts of accessory liability. Did they assist in, participate in communicating? So it's very broadly understood. I think very arguably, Facebook does communicate, right? They create algorithms that allow third-party content to be widely disseminated. They understand that this is what they're doing. This is, in fact, their entire business model, right? So you can very much argue, I think, that they're publishing. And you might actually think that's a good thing, right? They have a lot of power. They make a lot of money off of this, and so they should not be divorced from the realm of liability for this third-party content, because after all, they're the ones with the, you know, who's inviting this content and who is profiting from this content. So at the risk of getting into the weeds, there's one more concept I want to talk about, which is publication by omission. This is actually the one that tends to govern discussions of this issue. So the original case about publication by omission was about a bulletin board at a golf club, right? Nothing to do with the internet. It's called Byrne and Dean, Byrne versus Dean. And there was a bulletin board, and a member came along and posted this thing on the bulletin board that was allegedly defamatory of someone else. It was brought to the attention of the golf club, and they left it up there. And the court said, by refusing to take it down, you have made yourself a publisher of this content. So where the defendant controls a space, someone else, your third party, so in my Facebook analogy, Amar, who posts this post about me on Facebook, publishes something in that space. The defendant becomes aware of it. So without awareness, there's no publication by omission. You need notice. But I'm about to right-click on that post on Facebook and tell Facebook they're about to get notice, right? And does not remove it. And then I have another bracketed thing. There should be, for publication by omission, the ability to infer endorsement. Courts don't really apply that very rigorously. They tend to infer endorsement from a failure to remove, which in the Facebook context is going to make a big difference, right? Because I think you would not generally infer endorsement from a refusal to take down a third-party post in the Facebook context. The courts haven't concerned themselves too much about that one. So, long story short, or long story long, the law of internet intermediary liability tends to be governed by this kind of a doctrine, and with the I guess the additional point that they tend not to, they very readily infer endorsement if they talk about endorsement at all. Okay, so Facebook will be responsible if these circumstances, if these criteria are made out. So what's the problem here? I mean, you can imagine, you can probably imagine the difficulty here, or the incentive that this creates. I mean, what this means is, when I right-click on the post and say, that's a lie, it's not true, it's defamatory, Facebook has two choices. It can do nothing, but now it has notice. Now it's potentially a defamer where 5 minutes ago it wasn't. Or it can take the content down. It can take Amar's post down. And now it cannot be held liable. So you see, we now have a very powerful incentive to remove content on the basis of nothing more than a complaint, right? I mean, it sounds like censorship, except we're in a private space rather than a public space, so Facebook's entitled to do that. But a lot of people have written about I guess the lack of nuance in continuing to talk about public spaces and private spaces online, because so much of our democratic discourse happens in these kinds of privately owned spaces, so that we may want to protect them in ways that we didn't need to when there was greater availability of public spaces. Okay, so we have a real incentive here. What's the answer? Well, I won't say that I have an excellent answer to what to do about this problem, or a complete answer, but my colleague Emily Laidlaw and I, so Emily's at the University of Calgary, she and I wrote a paper for the Law Commission for its law reform project on defamation. And we proposed a solution to this that goes sort of as follows. No liability in defamation for intermediaries, for third-party content, right? But you impose on them other obligations to pass on notice, for example. Some of you may know that in the copyright context, There's an obligation on internet service providers to pass on notices when copyright holders make a complaint. So it's sort of modeled on that. And we do allow for the possibility of takedowns in certain circumstances, but they're quite narrow. So remove the incentive. Don't negate all responsibility on the part of intermediaries, but don't make it liability. So I have the source to that paper at the end if you're interested in reading all the details. I know my time is really short, but I'm going to just quickly talk about this issue of effective remedies. So something's online. Amar's posted that I'm a plagiarist. I want it down, right? I can hire a lawyer, file a statement of claim, pursue my litigation options, and maybe in 5 years I will have a court order which I can then attempt to enforce against an American corporation, and maybe a nice big damages award that the University of Manitoba will have to pay. But that's not what I want, right? That's just, it's not what most people want when we're dealing with these, with online content. What you really want is a takedown, right? So what can we do aside from the old model of litigation? Well, and I have quick, cheap, and effective, because I think those are the things you want in some alternative mechanism. You can rely on terms of service. I think often that is the cheapest and easiest way. By that I just mean, right-clicking and hoping that Facebook will take it down, hoping that the community standards or contractual obligations on a particular platform will help. Obviously, sometimes they will and sometimes they won't. But the problem, even if it works, you've got a problem of sort of a democratic problem here, right? No one elected Facebook or appointed judges to the Facebook court. There's no transparency. We don't know on what basis they're taking these things down. So back to the private sphere, public discourse in the private sphere, this sort of idea that intermediaries will make all these decisions, that the Googles and Facebooks of the world will make all these decisions about what stays and what goes, I think is problematic. An idea has been proposed a number of times that if you think something's false, defamatory or otherwise, you can have some sort of a flag, right? Some sort of a highlight or some sort of a little text box that will say, this is contested. Seems like a great idea. You don't censor anyone, but you perhaps protect people's reputations by noting that this is not perhaps very trustworthy content. I suspect you can imagine some of the flaws with this, right? Everything I don't like, I'm gonna flag, right? Everything bad about Trump, fake news. Everything good about Trump, fake news, right? So everything controversial is just gonna get flagged, right? And I think people will very quickly ignore these flags. There's another interesting set of research about whether our brains are actually very good about connecting that kind of information with the content of the story we're reading. We tend to sort of remember bits and pieces, and so it may be that it wouldn't actually help even if only sort of legitimately false stories were flagged. So that's not going to work very well. Special fast track proceedings. I think this is a really good idea, but again, just part of the answer, kind of like small claims, where you're just focusing on truth or falsity and some sort of declaratory remedy, maybe an injunction. Right? So Ireland, the Irish Defamation Act, Section 28, has a fast track proceeding just about truth or falsity. So no litigation about damages, no litigation about fault, no litigation about defenses other than truth, right? Just get straight down to brass tacks, and your remedy is declaratory, and you can get an injunction, but also if you have a declaratory remedy, the good players, right? The Facebooks, the Googles of the world will take things down. And the bad actors, I haven't even talked about them, but they're not taking it down anyway, so we'll just forget about that, right? Because there's only so much you can do about the companies that have no intention of complying with a foreign court order. An online dispute resolution, which can be connected to 3 or not. I don't know if you're familiar with the Civil Resolution Tribunal in British Columbia, but they've done some really interesting work creating online dispute resolution mechanisms. And they started as condo disputes, and I think maybe some small claims. They're doing small claims now for sure, and some motor vehicle. And it's this sort of triangle where you start at the bottom, and this automated system helps you to identify what your actual issue is, and helps you sort of in a lot of framing things, and ideally gets rid of some of the disputes. And you go up to the next stage, which is also largely automated, and a few more cases get sorted. And then you get to lawyers acting as kind of arbitrators or mediators at a higher level. But this is cheap. Well, compared to court, it's cheap, right? And it's been really successful in British Columbia. Query whether defamation is best suited to something like this, given that it's not just about money, right? People are really angry. People are very emotional. My studies show that people do not make logical decisions when it comes to defamation. So I think some combination of all these is probably where we need to go. And I've talked longer than I should, so I'll stop now and I will open it up to questions. But first I'll show you, there's my very long sources page. And the stare decisis thing, in case you're wondering, I meant to mention, so Rob Denet, the one with the funny quote about dueling, he's my podcast host on stare decisis. So if you are so interested, you can check out our blog, which is about the law in Canada and beyond. And yeah, so there's a link to it there, as well as to his paper, some of the Law Commission papers that we've written, the Law Commission's consultation paper, which sets out all the issues really nicely, and some of the difficulties. And then the last one's my empirical study that talks about things like rates of liability and corporate versus human, and damages awards and things like that. Okay, so now I really will stop and take your questions. Thank you.